You have a right to subrogation, you're saying.
Correct.
Explain that to me.
I mean, that's basically what it is, Your Honor. It's my right.
This defiant sovereign citizen walks into court claiming subrogation can settle his unpaid rent. But when the judge asks him to explain exactly what he means, his argument starts falling apart fast. Will his courtroom theory hold up, or will the judge shut it down?
And here's where things get interesting. The defendant says he agrees with what's owed, but he's trying to use a legal-sounding concept called subrogation to settle the account. The key question is simple. Does that concept actually apply here? The judge is about to find out.
Versus Roderick Smith.
Morning, Your Honor. Weiss appearing on behalf of Group 5.
Your name, sir?
How you doing, Your Honor? Roger Smith.
Thank you. All right, where are we, Jim?
The last time we were here, you told us to go out in the hall and make an arrangement. At that point in time, I agreed with Mr. Smith to waive the late fees, but not the month-to-month fees. We have prepared a consent judgment at that point in time for $1,755, which includes $217 in court costs, plus the January's rent and the month-to-month fee. He was to have paid it by January 29th, 2024. He hasn't paid it yet. So we're here right now in January, and I'd like the ability to add the February's rent and late charge to that amount. Because February's rent has not been paid either.
Well, but you said you had the judgment, but you didn't enter that. I didn't sign that judgment.
No, you didn't sign the judgment. I had submitted it to the court. The court set it up for hearing because they wanted to put the consent on their record. I have the judgment here, but the time for payment of that amount has expired. So I don't know what the court wanted to do.
All right. Sir, what's your position?
Yeah, Your Honor. So I agree with the terms of what's owed, but I would like to certify my rights in subrogation and settle the account.
Do what?
Certify my rights under subrogation and settle the account.
What does that mean?
In equity, settle this account because this has to do with equity.
That's to do with non-payment of rent.
Still, it's equity. That's what we're dealing with. So I do have a right to subrogation. And I would like to certify my rights to subrogation and settle the account.
Yeah.
Notice what the judge does here. Instead of simply accepting a complicated legal term, she asks him to explain exactly what he means and who the supposed third party is. That's important in court. Using legal terminology doesn't automatically create a legal right. If you make a legal argument, you have to connect it to the actual facts and law.
A right to subrogation, you're saying.
Correct.
Explain that to me.
Explain it to me.
I mean, that's basically what it is, Your Honor. It's my right. I mean, I would assume that the court would understand.
Explain what you think that means.
When a third party intervenes to take place or pay.
Okay, so who's the third party?
Basically, it's under my estate where they're administrating the claim from.
What estate?
My all caps name.
Your all caps name.
Correct.
Okay. So, first of all,
that exchange pretty much settles the issue. The judge separates two completely different ideas: settling an account and claiming subrogation. And once the defendant admits he isn't disputing the amount owed, the courtroom issue becomes much simpler. He needs to address the debt itself.
Under what you just explained to me, there is no right of subrogation.
So we can't settle the account under subrogation?
You can settle not under subrogation. What you've explained is not subrogation.
I mean, if you want me to actually give you the definition.
Oh, I understand what subrogation means. I was
Oh.
checking whether you do, because what you're saying is not subrogation. So
That's how I would like to settle the account, Your Honor.
well, settling the account and subrogation are two separate things.
Okay.
So if you want to settle the account, you need to pay it.
Okay.
It's as simple as that.
All right, no problem.
Okay, so Mr. Weiss, with February's rent, how much is owed?
With February's rent, sticking to the deal that Mr. Smith and I made last week, waiving the $225 in prior late fees, not including February's late fee, which is now due. Amount owing would be 3193, which includes the 217 in court costs.
3193.
Could I get a statement of that as well?
Well, I'll put it in the judgment.
All right, and how much time does he have to get that paid?
And now we have the actual outcome. The court is entering a judgment and giving him a specific deadline to pay. What started with a complicated argument about legal rights has ended with a very straightforward question. Can the judgment be satisfied by the deadline?
10 days.
You could allot me, Your Honor,
I can
just
give them up to the
14
20th.
days.
Just,
Okay,
Mr. Weiss, don't interrupt. Go ahead, what?
Yeah, that's fine. To the 20th.
I'll
is
give them
fine.
to the 20th.
That should be enough time.
So you're not disputing the figure,
No, sir.
and the parties are agreeable and the court would agree to go to the 20th of February.
Correct.
All right.
The court will bear with me. I will.
So what I'm going to do is I'm going to indicate, I'm going to find that there's no tribal issue after hearing rather than a consent judgment. And I will enter that judgment. So you'll have till that date to get that paid. You
Okay.
understand that?
Yes.
Wasn't that easier in the last case, Your Honor?
Not really. It almost went south.
I know you
Take-
made a face when I come up here.
Let him take a look at it. All right.
It's also a money
You've
judgment.
looked at over.
Yes, sir.
All right. You have any questions regarding anything contained on this?
No, sir.
All right. So I'm going to sign this, okay? And then if you need a copy, you can pick up a copy up front at the front counter.
Okay.
Okay. All right, I signed off. I'll enter that judgment. You guys
Thank you.
are all set.
All right.
All
Thank
right,
you.
thank you. Court calls the case of Danbury Park versus Carmen Donnell.
Good morning, Your Honor. Michael Zappin, P 68107 on behalf of the plaintiff.
Is Ms. Donnell here? Ms. Donnell? Hang on, counsel. We had received some communication from
Yes.
her this morning.
I'm here.
Oh, there she is. Okay.
Hello.
Hello, Ms. Donnell.
Had to
All right.
unmute. I apologize.
It's all right. All right, where are we on this case?
Your Honor, it's my understanding that she has a motion to set aside a default judgment. We have no objection to that. We also submitted documents for dismissal without prejudice, and new park manager, new apartment complex manager has their paperwork squared away. I don't want to take up the court's time.
Oh. Ma'am, you have no objection to that?
Your Honor, right now, it's, I don't. This is the first time I've heard of this.
Good morning. Is this for Donnell Carmen?
Yeah, I'm sorry.
Hello, Judge Sherry Riley, the new property manager at Danbury Park. I'm just now
Yes,
logging-
ma'am.
Is this the case for Donnell, Carmen Donnell?
Yeah.
Yes, it is.
Okay,
All
I'm
right,
just
Ms.
logging.
Donnell? Hold on, everybody stop for a minute. Ms.
Right.
Donnell,
Yes, Your Honor.
you filed a motion to set aside the default judgment, right?
Yes.
And they're not objecting to the setting aside of the default judgment. And they're also seeking to dismiss the case.
Okay.
No,
And
sir.
what I asked is whether or not you had a problem with that.
Your Honor, she just said no. So
She said no what?
that they're not agreeing to do that. I don't know what's going on. This is so
Me either
confusing.
now.
I know it went from 4,000 to almost 15,000 right now. So that's why I'm not understanding what's going on. And I don't know.
All right, let me start again. Counsel, my understanding is this was the defendant's motion to set aside the default judgment, right?
That's correct, Your Honor.
And that plaintiff was not opposing that.
That is the records that I have, and I got those from my partner. If the manager from Danbury can speak to that, I don't know if they have their numbers squared away. That we're going to dismiss it and then refile.
Okay, they may refile, but for this, my understanding is they're setting it aside and dismissing the case.
Because if my park manager has different information, that's just what I have in my records here. She's on the line. Could you address that from Danbury?
Absolutely. It was to be as if she followed through with the payment plan that was set up by Hawk. I did speak with the
Now, the second case takes a completely different turn. This isn't just about whether money is owed the parties or giving the judge conflicting information about recertification, income, paperwork, and a balance that allegedly jumped from around $4,000 to nearly $15,000. Before making a ruling, the judge needs the records and the parties to get their stories straight.
representative from the Hawk program at SOS Services, and they were only willing to pay up to $2,000. No other funds had been resolved. There's no resolution to the issue, and the documents have not been completed. Responsibility for the resident. I am new to the property. I've come on the 10th, but I've reviewed all her file, and she has not been compliant. It was to be dismissed if she were compliant.
That's not true. I recertified last year. After my recertification, I never received anything from you all. You're new. This is really old. I recertified. At that point, it said I owed $4,000. Right now, it says close to 15. I needed a copy of my recertification. I never got a copy of my recertification paperwork stating that I had no income, so the rent should have been zero. No, that's the issue. I never received anything as far as my recertification. And I did recertify.
And I believe that is true, Your Honor. I guess at this point, if I could just seek an adjournment, I'll leave it to the court's discretion.
Really? That's where I was headed anyway. Okay, folks. Somehow or another, everybody needs to get this resolved. I don't have a sticker.
Yes, Your Honor. And I wanted to say on the record, I've been up to that office numerous times. I've called over the course of a year. Either if no one's in the office, they never answer the phone. I mean, Hawk gave up on me because they couldn't get through to management. We're just now getting through to management, because this could have been resolved last year.
Okay, if you could both, since you're having a communication problem, you could both call my office. We're in our office from 9 to 5, Monday through Friday.
I've tried to do that. I've tried to call you guys. I'm getting no help. Okay. I had a lawyer that was working with me. He don't even want to work with me because there's no correspondence. There's no one to help me. I'm doing this by myself. So now it's $15,000. I don't understand that. How?
Okay, Ms. Donnell?
Yes, Your Honor. I'm sorry.
Right.
I'm really upset.
I can
This
tell.
shit's going nowhere, Your Honor. It's going, and next month, it's gonna be 20,000 in a minute.
Okay. I don't know that. All I can say is this. What counsel's indicated is that both you and the property manager need to call his office. And then you guys can have a discussion. It doesn't mean that you have to agree, but at least you can agree on exactly what anybody wants the court to do. Okay, so Ms. Donnell, can you do that for me?
Yes, Your Honor. I need my recertification.
Now, the second case takes a completely different turn. This isn't just about whether money is owed the parties or giving the judge conflicting information about recertification, income, paperwork, and a balance that allegedly jumped from around $4,000 to nearly $15,000. Before making a ruling, the judge needs the records and the parties to get their stories straight.
That when I recertified last year, that for some reason they've lost that. And now they're charging market rent from what I understand, and it's $1,300 a month. Can you believe that? For here, $1,300 a month.
Okay.
Yeah.
So you
that's
don't
what's
have
going
your,
on. I'm sorry,
okay,
Your Honor.
okay. So you don't have your
I
Go
recertified
ahead.
last March. Last March, I recertified in their office. I filled out the necessary paperwork to did the recertification. And at that time, I was getting unemployment, which ended in April. So that following month, my unemployment had ended and my income would have went down to zero. But I filled out the paperwork and everything and submitted everything I was supposed to submit. I never received any correspondence after that. I haven't been able to get in touch with anyone in that
Okay,
office.
all right, Ms. Donnell,
Yes,
let's
Your
do
Honor.
this. You got a property manager that's new, and you got certain information that she may not have. Okay? So why don't you contact counsel's office? He'll get in touch with his clients, and maybe you guys can have a meeting to try to clarify all of those issues, okay?
Yes, Your Honor.
All right, let me adjourn this matter out,
Thank you, Your Honor.
Thank you so
Yeah.
much. I appreciate it.
and I'll adjourn it to March 5th, 2024, 9 a.m. Okay?
Okay.
Thank you, Your
All
Honor.
right.
Thank you.
Thank
so
you.
much. Thank you.
This case highlights just how quickly a housing dispute can become complicated when paperwork, rent calculations, and communication problems collide. In the Danbury Park matter, Carmen Donnell disputed a balance that she said had grown from around $4,000 to nearly $15,000, arguing that she had completed her recertification and that her income later dropped to zero. The property's new manager disputed her account and said the file showed she had not complied with the requirements. Rather than immediately deciding the underlying dispute, the judge adjourned the matter and directed the parties to communicate through counsel so they could clarify the records and determine exactly what remained unresolved. In the second case involving Mr. Weiss and Mr. Smith, the court addressed unpaid rent and related charges, ultimately entering a judgment for $3,193 and giving the defendant until February 20 to pay. What do you think? Was the judge right to give the first dispute more time to be worked out instead of making an immediate ruling? And in the second case, was the payment deadline reasonable? Let us know your take in the comments. If you enjoyed this courtroom breakdown, hit that like button, share the video with someone who follows real court cases, and subscribe to the channel for more courtroom moments, legal disputes, and judges' rulings.